All rise. Oh yay, oh yay, oh yay. This Honorable Court of Appeals of Tennessee is now in session.
Excuse me while I reorganize, if I can. Good morning, everyone, and welcome. We're pleased to have you with us today. We had 3 cases on the docket, but the counsel in one became ill yesterday, and so the 3rd case is going to be reset. We will hear the other 2 cases in the order in which they appear. Let me remind counsel that each side has a total of 15 minutes, and that includes if there's multiple attorneys. And appellant counsel may reserve up to 5 of that 15 minutes for rebuttal. So when you go to the podium, after you've introduced yourself, please let us know how much time you would like to reserve, and we will we'll program the clock accordingly. Are there any announcements? Hearing none, please call the first case.
Charles Youree Jr. versus Recovery House of East Tennessee, LLC et al.
Good morning, Mr. Caparella.
Good morning, Your Honor. I'm Don Caparella of the Nashville Bar. I'd like to introduce co-counsel who will be arguing today. This is Edward Griffith from New York. He's admitted pro hac vice, and he has come down through the good graces of Delta yesterday to argue, but unfortunately the good graces of Delta did not include his suit.
Oh.
So we went to the Caparella fitting place, and he is wearing my suit today, and it doesn't really fit him, but please, we beg your forgiveness.
Well, I want you to know that I wish I could wear cheap clothes, but they look good on you.
And I'm arguing the case after this as well, so my suits will be arguing 2 of the cases this morning, but I'll only be arguing 1. So
this is our first My Cousin
The
Vinny.
only good news I've heard today is that you will only be arguing 1 of the cases.
Thank you. So
This is our first My Cousin Vinny moment. You realize
Yeah,
that?
this is good.
At least your suit wasn't destroyed by a muddy field. Yeah.
so he's wearing clothes as
Yeah.
to the
All right. Well, we appreciate it.
Please welcome Mr. Griffith to argue the case. Thank you.
All right, then welcome, and you look mighty dapper.
Well, thank you very much.
Now, Mr. Caparella has Shakespearean costumes as well. Was the head of the Shakespearean Society.
I think I've heard about that.
So you could have worn one of those.
Well,
So,
I'll try to live up to the eloquence of
very good.
Shakespeare.
All right.
I don't know if I can meet that standard.
With all of this distraction, would you like to reserve some time?
Yes, I think 4 minutes.
4 minutes, very good. The floor is yours.
Well, thank you. Well, this is a case that presents an opportunity to clarify the Tennessee law regarding alter ego liability. And the trial court made an error in thinking that the 3 required elements for alter ego liability that sets forth in several cases, including a Tennessee Supreme Court case from 1979, that's the Continental case. She made the error of thinking that one of the cases that we cited was the only case that so held. And that case, she correctly noted, was decided under Missouri law and not Tennessee law. But in fact, that case cites other Tennessee cases that are good law, including the 1979 case from the Supreme Court and a 2008 appellate court case called Pamperin. And so it's fairly settled law in Tennessee, as well as in many other jurisdictions, that the 3 required elements for alter ego liability are: 1, that the parent company is asserting complete domination over the subsidiary, and that's complete. It's the finances, the policies, everything that is done by the subsidiary is really coming from direction of the parent. Secondly, the second required element is that control is used to commit a fraud or some type of wrong. And in many ways, that's the most important element. Because the idea here, of course, is that in our system of capitalism, it's important to respect the integrity of corporations as a separate and distinct entity from their shareholders. And it's an extreme remedy to violate that principle, and that's why these three requirements are usually held in most jurisdictions. So the element of using that control to commit a wrong is the second element. And the third is that use of the control to commit a wrong is the proximate cause of the injury here. And so the trial court cited to a 1984 federal appellate court, Allen, that listed 11 factors that courts can consider to determine whether or not to pierce the corporate veil and impose alter ego liability. And those are factors that many state courts and federal courts will look to, but they are not a replacement for the three required elements. Those factors help the court assess whether the three factors are satisfied, but they're not a replacement for them. And if we the trial court really basically acknowledged that the complaint of Mr. Youree does not set forth any of those three required factors, and that's why she had to distinguish this Noranda case, which was the case decided under Missouri law. And in doing so, she looked at the Allen factors and basically said, well, some of the cases that the defendants are citing cite some of the Allen factors, and here some of the factors, such as common addresses, common employees, have been satisfied. And so she based the decision that alter ego liability was properly pled in the complaint based on analysis of some, but not all, of the Allen factors. The mistake in doing that, however, is that she didn't tie them into the three required factors because she didn't think those three required factors were part of Tennessee law. So this case gives you a nice opportunity to clarify that fact, say that the three factors, the three requirements set forth in the Continental case and the Pamperin case, several other Tennessee cases, are good law, and they have to be met in order to establish alter ego liability.
Counsel,
I'm sorry, go ahead.
No, please.
Well, you've correctly identified the elements, but they usually come into play in the trial court when a defendant files a motion dismiss for failure to state a claim under Rule 12. We already have a default judgment for damages, and an appeal. And so we don't have before this court a Rule 12 motion for us to review. So how do we get to the issue that you want us to discuss? Do we jump over hurdles to go there?
I don't think there are many hurdles to jump over, actually. I think it's pretty straightforward, and that is that this is a motion to vacate the default. And one of the cases that both parties cite to, and the district court cites as well, is the H.G. Hill case. And in that case, which also involved a motion to vacate a default based on a alter ego claim, the court said that one of the grounds for granting a motion to vacate a default is whether the allegations of the complaint just simply do not state a claim. Basically the same type of analysis as would be made under a motion to dismiss for failure to state a claim. And the rationale for that, set forth in this H.G. Hill case, is that what happens when a party defaults? Well, all of the well-pled factual allegations of the complaint are taken as, or deemed as true. But if you take all of those well-pled allegations and they fail to state a claim, the default should not be entered because the plaintiff really has not set forth the legal requirements for his claim. And that's the theory of this case. And we're saying that the motion to vacate is based solely on that argument, that the complaint, when we take all of the allegations as true, still does not set forth a proper alter ego claim, and the default really should never have been entered for that.
Yeah, I mean, I guess, counsel, what I'm concerned about here is your argument seems to call for us to ignore what our Supreme Court said about pleadings too. Notice pleadings. I mean, it's pretty clear here that's an alter ego claim. And if this was submitted to us on the first instance on a motion to dismiss for failure to state a claim, I'm not sure we wouldn't affirm a ruling that denied that motion because it's pretty clear what the claim is here. I mean, your complaint is really the underlying facts weren't stated. And I might agree with you on that point, but I'm not sure that's enough to get you to the point of vacating this judgment.
Well, our argument is that the only allegations really relevant to any of the Allen factors or any of the three required elements for alter ego liability are four allegations. One, that the companies maintain the same address, that they have common employees, that one of the companies that is the target of the alter ego liability, Recovery House of Tennessee, markets itself on the website maintained and operated by the judgment debtor. And four, on information and belief, there is no arm's length transactions between the companies. None of those allegations go to really any of the three required elements, but particularly if we focus on the second, which is that the complete domination has to result in a wrong or defrauding of the plaintiff. They don't touch on that, and so the complaint just fails to make out the required pleading to set forth a valid alter ego claim, and I think that would have justified a motion to dismiss, but it also justifies a motion to vacate. And I believe the issues and the policy considerations on both of those are relatively the same. And that is when a party defaults, the plaintiff gets a very big benefit, and that is all of his well-pled allegations are considered to be true. But if the pleading doesn't meet the requirements for a cause of action, I don't think there's any reason why the law should say that the plaintiff should get really a windfall, a real bonanza. Not only are his allegations, which very well might not be true, are going to be deemed true, but he will get the benefit of a valid cause of action even though he or she hasn't pled the required elements.
Don't we have to first consider, before we hear your issue on the merits, don't we have to first consider the trial court's ruling that the defendant's failure to file an answer and or to respond to the motion was willful?
I don't think so, and that's one of the points that my adversary made in his brief. But the willfulness, the requirement to show that there's no willfulness is connected with the argument that the default was through excusable neglect, and that's not what we're arguing. So the whether it was excusable neglect, whether the default was willful, is irrelevant to this separate ground for challenging the default, which is that
Isn't it a condition precedent? If a trial judge says your failure to answer and respond to the motion was willful, isn't that a roadblock to our considering the issues you want us to consider?
I don't believe so. I don't read the cases that way. I believe the cases dealing with willfulness, and they do say that it's the defendant's burden of proof to show that his or her actions were not done willfully, but that's always in connection with the argument of excusable neglect. I think the argument of excusable neglect is much more common than the argument that we're making in this case. If you look at the H.G. Hill case, which discusses this ground for a motion to vacate at some length, there's no tying in the willful aspect. I see that my time is gone.
All right,
I
thank you.
appreciate the time.
We'll hear from you further on rebuttal.
Thank you.
We'll now hear from the appellee. Good morning.
Good morning. May it please the court, my name is Ben Goldhammer. I represent the appellee Charles Youree. We were obviously requesting that the Court of Appeals affirm the trial court in all respects. Essentially, what the appellants do is they set up a straw man argument. They argue that the trial court applied an incorrect legal standard for veil piercing. Based on that, they argue that they're entitled to de novo review of that legal issue. And then they proceed to just knock the straw man down by arguing that the complaint fails to sufficiently plead the elements that they deem are necessary. I would submit to the court that the trial court should be affirmed for 4 separate reasons. Number one, the procedural posture at the trial court level was of a Rule 60 motion and only a Rule 60 motion. There was no Rule 12 motion filed. I guess they could have filed one simultaneously with filing the answer that they filed when they filed the motion to vacate. That was never done. A threshold issue in determining whether to vacate a default judgment is whether there is excusable neglect, which is essentially synonymous with willfulness. And the Tennessee courts hold consistently that the appellates bear the burden on that issue, and that is it's referred to as a threshold issue. You go no farther if you cannot show excusable neglect. Here, the appellates did not want to fight about excusable neglect at the trial court level because on our side we were pushing to test the allegations that were made in the affidavits they filed. We were pushing to depose the individual, Phil Newman, who swore under oath that he didn't receive these filings or didn't know he was supposed to respond. We were pushing to depose the lawyer.
Give us a moment.
I'm sorry.
You want to get a cough drop or a mint?
I've been working on it. I'm sorry.
It's quite all right. I just want to make sure you're okay. We can do
Yeah. I just downed one, and I'm about to down some others. I've got a pocket full. I apologize.
I guess it would be inappropriate for me to offer you a hottie toddy during court,
Well,
so I won't do that.
No,
So.
don't do that.
Okay.
I'm so sorry.
Oh, you're just fine. It's the human element, but we'll give you a little,
Sinus infection.
we'll give you extra time. So, but anyway,
Here we go. Let's.
very good, and thank you, Mr. Hollins, for the medical assistance. So,
Appreciate that.
all right, please proceed.
And so what came of that discussion about us wanting to test the appellate's proof that they put in the record about excusable neglect was they agreed to a stipulation. And the stipulation withdrew any argument of excusable neglect and stipulated that they would not challenge my default judgment on those grounds. But the trial court, when the motion ultimately came to be heard, the trial court went a step farther. And the trial court noted that there was no excusable neglect, that this was a situation of willfulness. These defendants engaged counsel in the first instance, different counsel than what we have here today who represented them. Counsel withdrew from the case. The defendants were then sent all the filings to the address that was indicated on counsel's motion to withdraw. The court concluded that it was simply a willful decision to, at that point in time when they knew a lawsuit had been filed, that they knew their lawyer had withdrawn, they'd been served via their registered agent with a motion for default judgment, that it was simply willful for them to just stand by and ignore all of that.
Well, counsel, I'm curious, do we care what the complaint says at all? You know, let's suppose, you're advocating here, don't look past the Rule 60 motion to get to the underlying complaint, but suppose the complaint here, and I know this is not the case, but suppose the complaint here contained not a single allegation against RHT. Didn't say a word about what they had done, how they were connected to the original judgment debtor, didn't say anything. And you were granted a default against both entities, including RHT. And RHT came back and said, you know, we looked at this complaint and thought it was a nothing and did not respond because there was no allegation against us. Default judgment's granted. Would they be entitled to Rule 60 relief under that instance?
Absolutely not. The reason simply being, you go down that road, and I get that if I filed a one-sentence complaint, I sue to pierce the corporate veil, I'm going to get kicked out of court on a Rule 12 motion. But if I get a default, the slippery slope of going down that path is you open the door to where is the line, and then you start to back the line up. And then every time there's a default, somebody may be midway through collecting a judgment. They may have already started collecting a judgment, and now you've essentially blown the door open on that default. It totally eliminates the finality that you get with getting the default and then letting the time frame to appeal run. So I think that that's a dangerous, slippery slope, and I think that, no, I don't think that that judgment should be set aside. Reason number two is, for the reason the trial court should be affirmed, is that even if we go down this road of looking at this from a Rule 12 perspective, the appellates conflate the idea of proof with pleading. Pamperin was a case that was brought up on appeal after a bench trial. Noranda was brought up on appeal after summary judgment, and neither one of those cases dealt with the question, what must be pled to survive a Rule 12 motion? And so even if we assume for a minute that Noranda and Pamperin are the state of the law in Tennessee, I don't see how we get past Rule 8.01. All a plaintiff has to do is provide a short and plain statement of the claim showing they're entitled to relief. The Webb standard, liberal construction, and only grant a Rule 12 motion when a plaintiff can prove no set of facts to support the claim. And I call it the Remax case. I'll try and call it the H.G. Hill case because that's how the appellates referred to it. But the H.G. Hill case is telling because that was a landlord-tenant dispute as well. Landlord sues tenant. Landlord realizes, I guess, tenant was insolvent, sues owner of tenant, and files an amended pleading, and essentially just parrots several of the Allen factors. Doesn't give any factual explanation, doesn't put any meat on the bone, and at the end of the day, the trial court and then the Court of Appeals affirms the trial court on that default judgment that went against the owner of the tenant entity. In this case, even applying that standard, my complaint went well beyond what took place in the H.G. Hill case, because in that case, all they did was parrot elements. In my complaint, I pled what I could plead under Rule 11, and that was, from what I can tell from my research, these entities have the same owner, they have the same employees, they have the same business operation, they're all running under the same moniker. One of them just happens to have assets. And so I would submit to the court that I go beyond what was pled in H.G. Hill, and based on that precedent, I think even if we focus on a Rule 12 analysis, I would survive. Reason three, I would submit to the court that Noranda and Pamperin just simply are not the state of the law in Tennessee. The Allen factors have been recognized for several years in Tennessee as being the standard, the touchstone you look to in deciding whether to pierce. The court first asked the question, has the conduct of the defendant been used to work a fraud or injustice in violation of public policy, and then looks to a series of factors to determine whether piercing is appropriate. It's largely equitable consideration. And the most recent Tennessee Supreme Court case on the issue is the Rogers case from 2012. And in that case, they did not cite the Noranda or Pamperin elements. Rather, what they did is they stated exactly what I just stated from the Allen test. They applied the Allen test. They happened to reverse the trial court's determination that piercing should have occurred, but they full-on applied the Allen analysis to determine whether piercing was appropriate. But if you really drill down on Pamperin and Noranda, I don't think that they stand for what the appellants say they stand for. Those are both third-party creditor claims. And so take Pamperin, for example. In Pamperin, the plaintiff bought a hot tub. And at the time she bought this hot tub from a company called Streamline, the company was still in business. Before the hot tub gets delivered, there is essentially a division of the assets of that business amongst the two shareholders. There was no adverse, wrongful, fraudulent conduct as to this plaintiff. She was just a consumer who bought a hot tub from a company that went out of business because the shareholders busted up. And the trial court declined to pierce. The Court of Appeals said, no, piercing would have been appropriate. And it would have been appropriate because taking assets from an entity and moving them to a shareholder essentially robs a third-party creditor of the ability to collect the judgment. So this is one of many consumers that this company had, one of many customers that this company had.
So do we have that in this case where the original lessee moved some of its assets to some of these two other entities that were sued in this case?
There's not a moving of assets, but and I'm getting beyond my pleadings, but here's what I would submit actually happened. You have three entities: Recovery Solutions Network, Recovery House of East Tennessee, and RHT Holdings. From what I can tell, and in part because there's been an adverse inference stipulation as to the defendant's financial records that they could not produce, they stipulated to that. But what I would submit is, of those three entities, there's only one with assets, and it was RHT Holdings. And it was an entity that owned a piece of dirt in Anderson County, Tennessee, unencumbered, where they would conduct addiction treatment services. And although all three of these entities traveled under the Recovery House moniker, two of them ended up apparently being insolvent. One of them had assets. Of all three of these entities, they're all owned indirectly, in total, by one guy, Phil Newman. They're all controlled as manager by Phil Newman. They can't produce a single piece of paper showing capitalization. They can't produce any bank records that even show transactions that were relevant to discovery, which is why they took the adverse influence.
Some people might say that when a landlord decides to lease to an entity that doesn't have any assets, that was probably a issue with the original transaction. There should have been a better credit check of the lessee to start with.
Yeah, thankfully I wasn't involved in writing the lease, so I can't say that. But what the point I come back to is there were copious facts in the record by the time we got to the motion to vacate hearing to show that I could push the button on multiple Allen factors. And that assumes we're disregarding the issue of excusable neglect, not to mention what was pled in the complaint. But I say that with respect to those cases because what the appellants hammer on when they come back to Noranda and Pamperin is that you have to show that the wrong, the fraud, was specifically targeted at the plaintiff. And if you really drill down on both of those cases, they're third-party creditor cases. Noranda was a case where a supplier of aluminum pellets just didn't get paid because the business went out of business and sold its assets. They aren't cases where there is a fraudulent conduct targeted at a third party. They're just third party creditor cases. And so I would submit to the court that those two cases do not stand for the proposition that in order to pierce, the wrong actor's conduct must be targeted directly at the plaintiff. My fourth reason...
You've got additional time. We're going to give you an extra minute.
My fourth reason as to why the Court of Appeals should be affirmed is exactly what I went through earlier, and that is we were not there on a Rule 12 motion. The court was not constrained to the four corners of the complaint. And that's why I put in the record everything I'd learned in discovery. That's why I got a stipulation saying that the financial records, if they had been produced, would be adverse to them on my piercing claim. Because I wanted to show the court that the court could look beyond the four corners of the complaint and that there was more than ample evidence if the court was to look beyond the four corners to pierce. And so for those reasons, I would ask that the court affirm the trial court in all respects.
All right. Thank you, Mr. Goldhammer.
Much.
All right. Mr. Griffith, you've got 4 minutes for rebuttal.
Thank you. Well, Mr. Goldhammer did mention that he was going to go a little bit outside of his pleadings when he talked about the discovery issues and things like that, alleging that he could, if it ever got to trial, set forth facts that would not only prove the allegations of the complaint, but go further than that and actually prove the 3 requirements under Pamperin and the other cases. Well, that may well be true, but that's not what the issue is before you today. The issue is what the complaint says and whether or not, taking all of the allegations of the complaint are true, it sets forth a valid claim for alter ego liability. The fact of the matter is, this is a unhappy landlord who entered into a lease without doing any due diligence in terms of whether his tenant had the funds to pay the rent if the business failed. And that's exactly what happened. The business failed. This was an underlying rehab, alcohol and substance abuse business. It failed when insurance requirements changed, and the tenant just didn't have any money and couldn't pay the lease. Now, Mr. Youree could have sought a guarantee from Mr. Newman, and actually, again, we're going outside a bit of the record, but he did, and Mr. Newman says no, and he still rents the apartment to a entity that he should have had some reason to believe that if the business went under, the lease would not be paid, and that's what happened. It would, in terms of policy, it would be a bad policy, I suggest, that if a situation like this, a landlord could always assert, well, we're going to pierce the corporate veil to get to the shareholder, who presumably would have assets. That's not what the law says. In fact, it's an extreme remedy. It should only be used when the 3 requirements of the Continental case are satisfied. Now, Mr. Goldhammer also argues that, well, Pamperin and those 3 requirements are no longer good law. This is a big issue. What are the requirements for alter ego liability? And in 1979, the Tennessee Supreme Court had a very detailed discussion of that. And in fact, these 3 requirements that we're talking about today, they at least date from the 1930s in a case by the Appellate Division in New York that's cited in the Continental case. So this is not an issue that is going to be overruled by not even addressing it. And so the suggestion that, well, the Allen factors have now been substituted in for these 3 requirements, I don't believe really is correct. I'll mention very briefly the point that Mr. Goldhammer started with, and that is the the showing of willfulness in connection with excusable neglect. All of these threshold cases, the cases that say the issue of willfulness is a threshold issue, they're all excusable neglect cases. For example, in the Discovery Bank case, the court says, when a party seeks relief from a default judgment due to excusable neglect, a reviewing court must first determine whether the conduct precipitating the default was willful. And so the willfulness issue is just simply not relevant when the argument is that the motion to vacate is justified, not because of excusable neglect, but simply because taking all of the allegations of the complaint as true does not set forth a valid cause of action.
All right, thank you, Mr.
Thank
Griffith.
you very much.
Thank you both for your arguments, and we'll take this matter under advisement. Please call the next case.